This is the Legal Aware presentation on flotations. It's part of a series on commercial legal issues which are relevant to domestic and international businesses. The presentations are intended for anyone interested in commerce, but who doesn't necessarily have a legal background. First, we're going to look at initial public offering. An initial public offering, or IPO, referred to simply as an offering or flotation, is when a company called the issuer issues shares to the public for the first time. IPOs are often issued by smaller, younger companies seeking capital to expand. They can also be done by large, privately owned companies looking to become public limited companies, or PLCs. For an IPO, the issuer obtains the assistance of an underwriting firm, which helps determine what type of security to issue, the best offering price, and the best possible time to bring it to market. There are many reasons why a company might wish to undertake an IPO and list its shares on a public market. The main reasons are usually to raise additional capital for growth or to reduce debt, perhaps at a time when a company has exhausted other sources of finance, such as bank loans, shareholder funds, and venture capital. There may be existing shareholders, particularly venture capitalists or fund managers, looking for opportunities to realise part of their investment. The main benefits of a listing include access to capital, providing a market for the company's shares, and employee commitment. Further advantages include ability to take advantage of acquisition opportunities. Profile. A listing will often improve the perception of a company's financial stability and transparency. There will also be an increased public awareness of the company through greater press coverage, and this may help sustain demand for the shares. Comfort for suppliers and customers. The fact that a company has undergone the rigorous due diligence and other processes required to obtain a listing may help to reassure customers and suppliers as to the company's financial standing. And greater efficiency. The rigorous disclosure requirements applicable to a listed company tend to promote better systems and controls, leading to greater operating efficiency for the business as a whole. A rights issue is a special form of shelf offering. With issued rights, existing shareholders have the privilege to buy a specified number of new shares from a firm at a specified price within a specified time. The essential aspects of a rights issue are an offer of new shares or possibly other securities, made to existing shareholders in proportion to their holdings, to be subscribed in cash nearly always at a discount to the market price, have the ability for the shareholders to realise the value of his rights to subscribe for the new shares by selling them in the market nil paid. Even if the shareholder does nothing, the right to receive any value over and above the subscription price if the shares which could have been taken up are sold in the market at a premium to the subscription price plus associated costs. A general meeting may be necessary for a rights issue. It's vital to ask at the outset, do the directors have authority to allot the new shares? And does the issuer have any restrictions on the number of shares it can issue? A company may still restrict the number of shares that it can issue by including a suitable provision in the constitution governing the company. This is a recent example of a large IPO. International law firm Freshfields Brookhouse Deringer had advised AIA, the Asian life insurance arm of AIG, on its $20.5 billion initial public offering and listing on the Hong Kong Stock Exchange. The deal represented a number of milestones: the largest ever insurance IPO, the largest ever single market listing in Hong Kong, and the third largest IPO in the world. The Magic Circle firms Allen & Overy, Freshfields Brookhouse Deringer, Linklaters and Slaughter & May have recently secured leading roles on Lloyds Banking Group's mammoth £22.5 billion capital raising. Lloyds announced a £13.5 billion rights issue, the largest ever in UK history, alongside a separate transaction that will offer bondholders £9 billion worth of contingent convertible notes, known as COCOs. Linklaters acted for Lloyds on both transactions. On the cash call, a Freshfields team advised a syndicate of 18 banks, acting as underwriters for the record-breaking deal. a capital markets partner led an Allen and Overy team acting for the banks on the Cocos deal. Of the banks, 6 are also leading the syndicate underwriting the Cocos offer. These are Citibank, Goldman Sachs, HSBC, JP Morgan, Cazenove, Merrill Lynch and UBS. We hope that you've enjoyed this Legal Aware presentation on corporate finance, IPOs and rights issues. You can keep up to date through our Legal Aware page on Facebook, and we also suggest that you look through the corporate finance information of commercial law firms to